next speaker, Liaora is a professor, a friend and a colleague from Tel Aviv University. She's a professor at the Faculty of Law, the director of the Minerva Center for Human Rights at Tel Aviv University. She served as editor-in-chief of the Journal of Theory and Criticism, the leading political theory journal in Israel, and as the editor of law journals Mishpatim, Yunei Mishpat, and Theoretical Inquiries in Law. Professor Bielski's main areas of research and teaching are criminal law, international criminal law, political trials, decisional justice, feminist legal theory, and the relationship between law, history, and memory. She is the author of Transformative Justice, Israeli Identity on Trial, and the Holocaust, Cooperation, and the Law, which is forthcoming at Michigan University Press. She will speak about the truth commissions between public and private.
Thank you all, and thank you for inviting me. My presentation, I changed a little bit the topic. It will be the right to truth between the public and the private. The last 2 decades have witnessed the emergence of a new human right, the right to truth. This right has been principally elaborated by regional human rights courts, such as the Inter-American Court of Human Rights and the European Court of Human Rights, which adjudicate claims brought by individuals against states for human rights violations. However, lately, there have been attempts to import this right into international criminal law, a field that originated at Nuremberg but developed rapidly in the 1990s. The most famous institution currently being the International Criminal Court in The Hague, where individuals are prosecuted for having committed heinous crimes such as war crimes and crimes against humanity. Most scholars portray the development of a right to truth as a natural and seamless progression, forming part of a movement to end impunity. Today, I would like to challenge that complacent stance by uncovering discontinuities and changes in the understanding of the truth that occur when a victim's right to truth is transplanted into a criminal trial. In international human rights law, the starting point is the emergence of the right to truth in Latin America during transitions from authoritarian to democratic regimes beginning in the 1980s. In the face of practices of forced disappearances, the clarification of the factual truth took particular importance. This is especially so given that denial and concealment continued for decades through sweeping self-amnesties. The clandestine character of the crimes also explains why families of the disappeared were at the forefront of the struggle to establish the truth and present this struggle as a basic right to know the fate of family members, to bury and mourn them. Since typically the previous regime retained a broad power base, it was not possible to challenge the amnesties often granted to members of the military forces. The invocation of a right to truth thus originated as a second best to criminal prosecutions of perpetrators from the prior regime. If you can't try them, at least you'll know what they have done. The new regimes initially resisted the calls for investigation, but eventually embraced the demands for truth as an alternative to criminal investigation. They privileged truth commissions over criminal prosecutions by stressing the fragility of democratic transitions. However, this justification for truth commissions took a major turn with the establishment of the Truth and Reconciliation Commission in South Africa. This commission was justified as preferable for criminal trials under theories of restorative justice, according to which establishing the truth and altering attitudes towards victims were essential conditions for the return of democracy and the rule of law. Proponents of this approach argued that in criminal trials, the truth and the role of victims are necessarily more limited due to other values such as the defendant's due process rights. Truth Commission, by contrast, could allow for an investigation of patterns of abuse over a period of time and the search for root causes of repression. So this is the best alternative, not the second best. The development of Truth Commission as an alternative to criminal trials also meant that the process was liberated from the need to focus on defendants' rights, instead accentuating victims' right to know what had happened. Truth Commissions focus on victims, usually collecting thousands of testimonies and honoring these truths in a public and officially sanctioned report, represents for many the first acknowledgement by a state body that their claims are credible and that the atrocities were wrong. Under this framework for uncovering truth, victims did not initially enjoy a privileged position vis-à-vis society. To the contrary, in South Africa, when the victims tried to challenge the arrangement of an amnesty in exchange for confessions under the TRC by claiming their right to justice, that is, to criminal and civil trials, the South African Constitutional Court rejected their petition, subsuming their right under a society's right to truth, healing, and reconciliation. So society overcame victims. Against this background of the Truth Commission as an alternative to criminal trial, we can examine how the development of a right to truth achieved incremental changes in our understanding of the search for truth until it came to mean a legal right of the individual victim to have the state conduct criminal prosecutions. When victims in Latin America turned to regional and international institutions to pressure the state to investigate and prosecute, they redefined the right to truth not only as the collective right of a society to have the state fulfill its obligations to investigate the truth about crimes, but also as a private right belonging to the victim by virtue of the right to access justice. How did this shift come about? In the context of human rights litigation, which positions victims in relation to the state and not to a criminal defendant, the attention gradually shifted from the collective to the individual victim, who was asking for a remedy. Thus, the Inter-American Court has found that individuals can require that states criminally investigate and prosecute those believed to be responsible for the violations. As explained by one writer, victims' claim to criminal prosecution as a remedy have come to mean that prosecutions become a justiciable right that victims should be able to claim against the state. The result is a dramatic change. Truth-seeking is understood no longer as an alternative to criminal trial, but as a justification for criminal prosecutions. Truth commissions were no longer seen by the court, the Inter-American Court, as an alternative, but rather as complementary mechanism to criminal trials. And I quote one decision of the court. It says that the value of Truth Commission is that they are created not with the presumption that there will be no trials, but to constitute a step towards knowing the truth and ultimately making justice prevail. So they completely flipped the understanding of the South American Truth Commission. The initial dilemma that structured the field of transitional justice as a compromise between truth and justice recognized that transitions might require amnesties. However, with the recognition of a victim's right to truth translated into a right to criminal investigation of the truth, this was no longer the case, and courts began to nullify amnesties for grave human rights violations. This development is usually presented as part of a movement to end impunity. What has gone unnoticed is the key part played by the right to truth in blurring the differences between international human rights law and criminal law. The strengthening of the individual victim in the case law of the Inter-American Court through the recognition of a victim's right to truth did not end with the recognition of a victim's right to require criminal prosecution by the state, but included the court's further recognition of participation rights of victims in domestic criminal proceedings. It is this step that has found its way into international criminal law. Ordinary criminal trials assign victims a very narrow place, usually as witnesses for the prosecution, in its search for truth about the guilt or innocence of the defendant. This narrow focus on individual perpetrators has been criticized by scholars as constituting an obstacle to dealing with both the complexities of situations of large-scale conflict and the severity of mass crimes. Thus, the turn to truth as an independent and overarching goal of the international criminal law should be understood in the context of a general recognition by professionals in international criminal law of the unique character of state-sponsored, systematic mass crimes, requiring a different kind of investigation than in ordinary criminal trials. So the beginning in international criminal law was Nuremberg. The collective nature of the crimes led to an expansion of the goals of the trial beyond traditional objectives such as retribution, to include an autonomous objective, the clarification of history. In order to establish a contested historical truth, procedural rules were changed to allow the presentation of new kinds of evidence, such as expert testimony from historians who were not eyewitnesses. Important for the present purposes is the fact that under the framework of international criminal law, in the 1990s, interest in the truth was still seen as a collective, the interest of society as a whole, as well as of the international community. The search for truth in international criminal trials was also shaped by the discourse of victims' rights. The prosecution of mass crimes planned from above posed challenges in relation to eyewitnesses' testimonies of victims who typically witness only operations on the ground. In addition, the horrors and magnitude of the crimes and the traumatic experiences of victims triggered concerns that the testimonies would appear unreliable and motivated by revenge. Indeed, this was the rationale behind the decision of the American prosecution at Nuremberg not to allow Jewish victims to testify at all. At this early stage, the objective truth was contrasted with the subjective emotions of the victims, and accordingly, the architects of Nuremberg preferred Nazi documents over eyewitness victims. A decade and a half later, during the Eichmann trial here in Jerusalem, over 100 Jewish victims were given a platform to extensively tell their personal stories. But precisely for this reason, the trial has been considered by the international community a form of victims' justice. Change began only in the 1990s with the establishment of special tribunals for the former Yugoslavia and Rwanda. The change is linked to broader trends such as the victims' rights movement, the rise of therapeutic approaches to testimony, and the activities of feminist organizations. Although these changes have been examined by scholars of international criminal law, they are presented through a narrative of continuity. In contrast, I would like to point to the radical change and complete reversal in our understanding of the relation between truth, victims, and justice. Indeed, in contrast to Nuremberg, some current theories view the justice of international criminal trials as dependent on increasing the participation of victims, who are seen as contributing to the clarification of the truth. Some even see the victims as the raison d'etre for international criminal trials. As in international human rights law, where the truth was gradually juridified and individualized, in international criminal law we notice a parallel process of change. Here, the truth is gradually transformed from an overall goal of the trial into a private right of the victim, first to voice and protection, and later to active participation. The Rome Statute, establishing the International Criminal Court, granted victims not only protection and voice, as in the previous ad hoc tribunals, The new understanding of victims, not only as witnesses for the prosecution, but as participants in the criminal trial, sits better with the active role of victims in human rights courts and facilitated the rapprochement of the fields and the borrowing of doctrines from human rights law into criminal law. Significantly, this enabled the victims to request broader participation rights through a creative invocation of their right to truth. And I'll give a few examples. Article 68.3 of the Rome Statute conditioned the participation of victims in the criminal process on showing that their personal interests are affected. It says, where the personal interests of victims are affected, the court shall permit their views and concerns to be presented. The difficult question is where to draw the line between participation as victims and participation as full party to the trial. Can victims be turned into quasi-prosecutors given the limitation on victim participation? In the case of Katanga, the single judge answered in the affirmative, explaining that victims have a core interest in the determination of the facts, the identification of those responsible, and the declaration of their responsibility. She reasoned that the issue of guilt or innocence is inherently linked to the right to truth, and that the search for the truth can only be satisfied if those responsible are declared guilty, and those not responsible are acquitted, so that the search for those who are criminally liable can continue. The judge presented her decision as conforming with international human rights law, and particularly with victims' right to truth. However, her interpretation in effect nullifies the condition of a personal interest of the victim set by Article 68, by blurring the functional distinction between a prosecutor and a victim. It therefore raises a concern about undermining the adversarial principle of equality of arms between prosecution and defense. While domestic criminal law makes an important distinction between legal truth and factual or historical truth, the judge explains that the interest of the victims in truth requires closing the gap between them. We saw that this rationale was developed in the context of truth commissions that were presented as an alternative to a criminal trial. Here, in contrast, the demand to overcome criminal law's limitation on ascertaining legal truth is made in the context of a criminal trial, implicitly undermining the presumption of innocence in the name of the victim's right to truth. Moreover, this truth is no longer the interest of society at large, but is linked through the court's interpretation to a personal interest of the victim, thus bringing about an individuation of the truth not present in earlier international court law jurisprudence. Do I have some more time? Great. So I'll give you another example from the opposite direction. The measure of change can be gleaned when we turn our attention to arguments put forward by representatives of the accused. Here, I explore the defense counsel's argument that victims should be subject to an obligation to disclose exonerating evidence known to them, similar to the obligation put on the prosecution in a criminal trial. So, basically what they say, if the victims get a right to truth, so they have also a duty to disclose exonerating evidence. Interestingly, the impact of the truth discourse is so overwhelming that the defense does not base its demand on traditional due process rights of the accused to a fair trial, but rather on the right to truth of the victims. And I quote, "The accurate determination of the guilt or innocence of persons prosecuted before the ICC is important, not only for the accused who has the presumption of innocence, but also for the wider audience, in particular for victim participants, insofar as this issue is inherently linked to the satisfaction of their right to truth." Note, though, that the defense tries to resist the tendency to individualize the right to truth by expanding the circles of victims to be considered. And he says, victims who do not participate in the proceedings also have a right to know what occurred, who is responsible, and to which extent. If relevant and available evidence is not presented to the court, victims who do not participate in the proceedings, as well as other interested persons, may also be deprived of justice. And finally, the defense questions the unproblematic association of victims and truth. In contrast to the prevailing discourse that presents victims' participation as a disinterested intervention to assist the court in establishing the objective truth, the defense calls attention to the potential partiality of victims, as their right to compensation in the trial is dependent on the determination of the guilt of the defendant. In conclusion, we see that under the umbrella of a victim's right to truth, a new truth regime being established at the ICC, a regime that is neither a return to ordinary criminal law nor a simple imitation of the logic of truth commissions. Taking a critical approach to this transformation, I ask, what sort of truth should the ICC pursue? Who are the new experts of truth? And what should be the role of victims in relation to the search for the truth? And what checks and balances and oversight mechanism could be set up to counter the court's new powers and responsibilities? My analysis shows that the debate about victims' participation and their role in transitional justice mechanism and criminal law carries implications for the construction of collective memory. In truth commissions, the process is perceived as fulfilling a public objective of rebuilding and rehabilitating a society, and optimally a process which involves the entire society. In it, we saw there is room for victim stories, but not to vindication of individual rights to justice. A criminal trial by its nature belongs to public law, where the prosecutor represents the collective, but the process is focused on an individual perpetrator. When victims are given participation rights, they can correct some prosecutorial biases, for example, by allowing a more gendered perspective and by exposing the court to alternative histories. However, the individuation of the truth, especially in a criminal court, might undermine the idea of an objective truth produced by a court of law. Then the question arises, when victims participate, are they doing it on behalf of their own interest or to further a more collective goal, or both? As we saw from the above analysis, the ICC system itself is ambivalent. Thank you.